Start. Precisely, comma, a suit for specific performance of agreement to sell dated 8/6/2004 was instituted by the respondents number 5 and 6 against the present petitioner, comma, which was dismissed after recording statements of the parties, comma, with regards to settlement on 16/6/2005, comma, to the concerned suit by the London Trial Court on 20/6/2005, full stop. The respondents number 1 to 4 earlier filed a separate suit for specific performance of agreement to sell dated 2/9/2004, plaint whereof was rejected by the London Trial Court on 20/12/2013, against which appeal was preferred, which was withdrawn on 22/4/2013 by the respondents number 1 to 4, full stop. The respondent number 1 filed application under section 12 subsection 2 Code of Civil Procedure 1908 seeking setting aside of the order dated 26/2005 passed by the London Trial Court in the suit for specific performance instituted by the respondents number 5 and 6 against the present petitioner, full stop. The London Trial Court, without framing of issues and recording evidence, proceeded to accept the said application and reviewed the suit titled Sultan Imtiaz ul Hassan etc. versus Muhammad Nawaz Kasuri by setting aside order dated 26/2005, hence, the instant revision petition, full stop. Para. It means that the respondents number 5 to 6 at the time to entering into agreement to sell dated 8/6/2004 were granted powers to enter into further agreement to sell on the basis of the said agreement to sell, and by exercising the given right, the respondents number 5 to 6 entered into agreement to sell dated 2/9/2004 with the respondents number 1 to 4 and received certain amount in cash and through pay orders for different dates were issued, full stop. It is evident from record that the respondents number 1 to 4 firstly instituted a suit for specific performance of the agreement to sell dated 2/9/2004 against the respondents number 5 and 6 with simple prayer of specific performance of agreement to sell, but they failed in achieving the required result and withdraw the same on 9/7/2008, full stop. Again, they filed second suit in the year 2009 for specific performance of the agreement in their favor and also added alternative relief claiming compensation of 3 crores including the damages, which was dismissed being barred by limitation by the London Trial Court, and appeal bearing appeal number 1400 of 2013 was withdrawn by the respondent number 1 to 4, meaning thereby they had availed the remedies provided under law and failed to get a favorable decision in their favor, full stop. When the respondents number 1 to 4 remained unsuccessful and could not prove their stance by instituting an independent suit for specific performance against the respondents number 5 and 6, they have tried to get the same under the garb of filing application under section 12 subsection 2 Code of Civil Procedure 1908 under discussion, no one can be allowed to reopen a chapter, which has already been closed, because as per stipulation made in the agreement dated 2/9/2004, the respondents number 1 to 4 were bound to pay the balance consideration amount rupees 56,912,000 to the petitioner by 21/10/2004, but they did not do so, as is evident from the contents of their application, full stop. Therefore, as observed above, when the respondents number 1 to 4 could not succeed in their suits for specific performance of agreement dated 2/9/2004, as the same was dismissed being barred by limitation, the limitation for filing an application under section 12 subsection 2 CPC would also apply to this appeal, number 3427 of 2014, application comma, as has been held, full stop. Nobody could be allowed to do indirectly what law barred him from doing directly, full stop. In the above judgment, the Superior Court of Pakistan further held the Supreme Court of Pakistan further held that the only object of the petitioner in moving the present application under section 12 subsection 2 CPC is to re-agitate the issue which already stands closed on account of his withdrawal of the suits, full stop. The petitioner cannot be allowed to do indirectly what the law bars him from doing directly, full stop. We also agree with the contention of Mr. Gulzar, senior advocate, Supreme Court, that an application under section 12 subsection 2 CPC being a substitute for a suit, the limitation imposed by law on filing of suits were relevant for applications under section 12 subsection 2 CPC, full stop. In addition to above, order 6 rule 4 of the Code of Civil Procedure, 1908 provides that in all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, default or undue influence, and in all other cases in which particulars may be necessary beyond such as are exemplified in the forms aforesaid, particulars with dates and items necessary shall be stated in the pleadings, full stop.